Hello everyone, today we will discuss business laws and regulation regarding RA 11232, also known as the Revised Corporation Code, Title 16 and 17, as well as RA 8799, Chapters 1 to 3. Let's start first with Title 16, Investigations, Offenses, and Penalties.
In any case that the revised corporation code or any rules, regulation, or orders of the SEC was allegedly violated, they may investigate and publish the findings, orders, opinions, or information of the said violation. Of course, it is subject to the provisions of RA 10173, otherwise known as the Data Privacy Act of 2012. Other pertinent laws may also apply. SEC shall also provide reasonable notice with the appropriate regulatory agency prior to such publication involving the companies under the special regulatory jurisdiction. The Commission, as an agency, cannot move or investigate itself. It can only be done by a designated officer by the Commission, which he can administer oaths and affirmation. Second, of course, he can issue subpoena and subpoena ducis tecum, or a writ ordering a person to attend a court and bring relevant documents. Third, that person can take testimony in any inquiry or investigation. And lastly, he may perform other acts necessary to the proceedings as requested and required by the Commission. The SEC may issue a cease and desist order ex parte to enjoin an act or practice which is fraudulent or can be reasonably expected to cause significant, imminent, and irreparable danger or injury to the public safety or welfare. And after that, the SEC may also proceed administratively against such person in accordance with Section 158 of this code, or transmit evidence of the Department of Justice for preliminary investigation or criminal prosecution, and or, depending, initiate criminal prosecution for any violation of this code, rule, or regulation. Since the SEC is not granted with unlimited powers, it is not a god whose every order becomes incapable of making mistakes. It is legally doubtful if it may lawfully impose administrative sanction when any of its order has been violated as separate and distinct offense from the violation of any provision of this code, rules, or regulation. Provided here in Section 166, keep in mind that every corporation is a medium of conducting business. There would be no difference in the coverage between Section 165, discussed later, when it refers to a corporation that conducts its business through fraud, from Section 166, which refers a corporation used for fraud. That can only mean that the criminal offense committed by a corporation is well defined only when proper reference can be made to statutory provisions that define particular acts of the directors, trustees, or officers as constituting graft or corrupt practices, like Anti-Graft and Corrupt Practices Act. For this title, I will summarize the rest of the provision for better understanding. So let's start first with failure or refusal to comply with any lawful order, decision, or subpoena of the Commission. You will be fined not exceeding 30,000 pesos. Up next is, if there is a clear or open defiance in the Commission's order, decision, or subpoena, you will be fined daily of 1,000 pesos until you comply with such order. Next is unauthorized use of corporate name. With such, you will be fined 10,000 pesos to 200,000 pesos. We also have there that despite of the knowledge of the existence of disqualifications, such director, officer, or trustee willfully holds the office or conceals such disqualification, that officer will be fined 10,000 pesos to 200,000 pesos and shall be banned or disqualified to any corporation as a director, trustee, or officer. And if it detriments the public, they will be fined 20,000 pesos to 400,000 pesos. Next is, if there is unjustified failure or refusal by the corporation or by those responsible for keeping and maintaining corporate records, they shall be fined 10,000 pesos to 200,000 pesos, and if it is detrimental to the public, they will be fined 20,000 pesos to 400,000 pesos. Up next right here is willful certification of incomplete, inaccurate, false, or misleading statements or reports. With this, you will be fined 20,000 pesos to 200,000 pesos. And if it is detrimental to the public, you will be fined 40,000 pesos to 400,000 pesos. Next is, if an independent auditor, an outside auditor, certifies the corporation's financial statement despite its incompleteness or inaccuracy, such independent auditor will be fined 80,000 pesos to 500,000 pesos. And if it affects the public, such auditor or officer responsible for that incompleteness will be fined 100,000 pesos to 600,000 pesos. Next is obtaining corporate registration through fraud or those who assisted directly or indirectly or those who are accomplice. So with that, they will be fined 200,000 pesos to 2 million pesos. And if it is detrimental to the public, they will be fined 400,000 to 5 million pesos. We also have corporation that conducts its business through fraud, which is mentioned earlier. Having this, you will be fined 200,000 pesos to 2 million pesos. And then if again, detrimental to the public, you will be charged 400,000 to 5 million pesos. Lastly is this chart, which states that corporation that appoints an intermediary who engage in graft and corrupt practices for the corporation's benefit or interest will be charged 100,000 pesos to 1 million pesos. Next is tolerating graft and corrupt practices. They will be charged 500,000 pesos to 1 million pesos. Up next is any person who commits acts detrimental to a whistleblower. Whistleblower are those who give information regarding a fraud or misconduct. That person who detriments the whistleblower will be fined 100,000 pesos to 1 million pesos. And lastly, violations of any of the other provisions of or its amendment not otherwise specially penalized, they will be penalized not less than 10,000 pesos or not more than 1 million pesos. And if the violation is committed by a corporation after notice and hearing be dissolved in appropriate proceeding before the commission. Section 171 refers to situation where the offender is a corporation. This is the legal basis by which the court may include the offending directors, trustees, shareholders, officers, or employees who are directly responsible for the violation or indispensable to its commission. Since a corporation is a juridical person, it can only commit crimes through acting directors or trustees, stockholders or members, officers or employees, and therefore such natural persons are always responsible for the violation. Section 172 may be employed as the legal basis to hold legal counsel, accountants, financial advisors, or other consultants liable for advising or counseling the corporate officers into actions and projects that would be construed as any violation of the revised corporation code. It is whether such violation would constitute criminal or civil infraction. No criminal conviction can be imposed upon an aider, abettor, or counselor until the principal offender is convicted, since this section imposes the punishment is with a fine not exceeding that imposed of the principal offender.
For the Section 170 outstanding capital stock defined, the term outstanding capital stock as used in this code shall mean the total shares of stock issued under binding subscription contracts to subscriber as stockholders, whether fully or partially paid except treasury shares. An example would be if a company with the authority to issue 10,000 shares of capital stock only 8,000, in which case the 8,000 shareholders would own all of the company. So every outstanding shares of stock any class has the same rights and benefits as any other outstanding shares in that class. Unissued shares are authorized shares that have yet to be issued. So, these shares have rights associated with them once they are issued. So, they cannot vote as stockholder, meeting, or receive dividends. There may be discrepancy between the amount of share issued and the amount of share outstanding. For the Section 174 designation of governing boards, the provisions of specific provisions of this code to the contrary notwithstanding, non-stock or special corporations may through their articles of incorporations of their bylaws designate their governing boards by any name other than as Board of Trustees. For the Section 175 collection and use of registration, incorporation, and other fees, the SEC is authorized to collect, retain, or uses fees, fines, or charges. Amount collected should be deposited and maintained in a separate account. For capital outlay, increase in compensation and benefits, reasonable employee allowance, employee healthcare services, other insurance, employee career advancement and professionalization, legal assistance, seminars, and other professional fees. The National Economic and Development Authority, as defined by the Article 14 of the Constitution, is tasked with determining whether corporate vehicles have been utilized to circumvent the terms of this code and reporting to Congress in any findings or recommendation to prevention or correction. So, the Philippine Competition Act or RA 10667 allows Congress to impose maximum restrictions on the amount of stock that people or groups of individuals related to one another by consanguinity may acquire, and this is done to stop anti-competitive behavior. NEDA will take into account the industry's size, scope, economies of scale, location, export potential, and other aspects. For the Section 177 reportorial requirements of corporations, except as otherwise provided in this code or in the rules issued by the Commission, every corporation, domestic or foreign, doing business in the Philippines shall submit to the Commissions. Letter A. Annual financial statements audited by an independent certified public accountant, provided that if the total assets or total liabilities of the corporation are less than 600,000 pesos, the financial statements should be certified under oath by the corporation's treasurer or chief financial officer. For the letter B, a general information sheet, corporation vested with the public interest must also submit the following. Number 1, a director or trustee compensation report, and number 2, a director or trustee appraisal or performance report, and the standards or criteria used to assess each directors or trustee.
For the Section 178 visitorial power and confidential nature of examination results, the SEC will have visitation authority over every firm. If a corporation refuses to exercise its visitorial right or obstructs it, the SEC may cancel its certificate of incorporation. For the Section 179 powers, functions, and jurisdiction of the Commission, in imposing penalties and additional monitoring and supervision requirements, the Commission shall take into consideration the size, nature of business, and capacity of the corporation. For the Section 180, development and implementation of electronic filing and monitoring system, the Commission is responsible for developing and implementing an electronic filing and monitoring system to accelerate and streamline the following processes: corporate name reservation and registration in corporation, submission of reports and these documents that are required by this code, and sharing of other government agencies, among other things, the Commission will establish these rules. For the Section 181, the arbitration of corporations, an arbitration agreement may be provided in the Articles of Incorporation or by the laws of unlisted corporations. According to this section, corporation or bylaws of Article of Incorporation may contain this arbitration agreement. So, the Securities Exchange Commission or the SEC, subject to current arbitration legislation that will create rules and regulations that will regulate arbitration according to the same section. For the Section 182, jurisdiction over party-list organizations, it is specifically stated in Section 182 of the Revised Corporation Code, which states that the Securities Exchange Commission rights, duties, and obligations relating party-list organization are transferred to the Commission on Elections. The monitoring, supervision, and regulation of such corporations shall be automatically transferred to the COMELEC within the 6 months after the effective of this Act. For the Section 183, applicability of the Code, this law in a way amends the provisions of current special laws that control the registration, supervision, regulation, and oversight of special corporations, including insurance firms, banks, and non-financial institutions. Under their supervision and regulation, special corporations, including banks, non-bank, financial institutions, and insurance firms, are subject to primary authority from regulations like Insurance Commission and the Bangko Sentral ng Pilipinas, regardless of any provisions to the contrary. For the Section 185, applicability to existing corporation, a corporation lawfully existing and doing business in the Philippines affected by the new requirements of this code, and it shall be given in a period for not more than 2 years from the effectivity of this act within which to comply. For the Section 186 separability clause, in the event of in any provision, part or application of this for to any person or situation and deemed invalid, it shall not have an impact on other provisions or sections of this part of how much provisions or sections apply to other people or situations. For the Section 187 repealing clause, a repealing clause, it is a provision in legislation that revokes or annuls a prior statute. It is statutory provision that nullifies a previous statute. For example, if there is legislation that prohibits the sale of alcohol on Sundays, but had a new law that is passed that allows alcohol sales on Sundays, the new law will include a repealing clause that nullifies the old law. For the RA 8799, Chapter 1, Title and Provisions, Section 1, Title, this shall be known as the Securities Regulation Code. Section 2, Declaration of State Policy. According to implementing rules and regulations of Republic Act of 8799 or Securities Regulation Code, it is the Securities Exchange Commission that monitors compliance of financing and lending companies with existing rules, laws, and regulations and endorses infractions thereof to the Enforcement and Investor Protection Department. 3.1 is for the securities. It is the shares, participation or interest in a corporation or in commercial enterprise or profit-making venture, and evidenced by a certificate, contract, instrument, whether written or electronic, in character. Then, 3.2 is what we call issuer. It is the originator, maker, obliger, or creator of the security. 3.3 is what we call broker. It is the person engaged in the business of buying and selling securities of the account of others. 3.4, dealers, means any person who buys and sells the securities for his or her own account in the ordinary course of business. 3.5, associated person of a broker or dealer. It is an employee thereof who directly exercise control of supervisory authority, but it does not include a salesman or an agent or a person whose functions are solely clerical or ministerial. 3.6 is a clearing agency. It is any person who acts as intermediary in making deliveries upon payment to effect settlement in securities transactions. 3.8, insider means A, the issue. Letter B, it is a director or officer or person performing similar functions or person controlling the issuer. Letter C, it is a person whose relationship or former relationship to the issuer that gives or gave him access to material information about the issuer or the security that is not generally available to the public. Letter D, it is a government employee or director or officers of an exchange, clearing agency, and self-regulatory organization who has access to material information about an issuer or security that is not generally available to the public. Letter E, it is a person who learns such information by a communication from any of the foregoing insiders.
This code shall be administered by the Securities and Exchange Commission. It is also referred to as the Commission, which is composed of a chairperson, which is also the CEO of the Commission, and 4 commissioners appointed by the President for a term of 7 years each, and shall serve as such until the successor shall be appointed and qualified. Commissioners must be natural-born citizens of the Philippines and at least 40 years old for the chairperson and at least 35 years old for the commissioners. They must come with good moral character and majority shall be a member of the Philippine Bar. Their salaries shall be fixed by the Philippine President and shall hold meetings at least once a week or as often as needed upon the call of a chairman, 3 commissioners, or most senior commissioner. The same number will constitute a quorum for the meeting, which is 3 commissioners. Here in Section 5, the Commission shall have, among the others, the following powers and functions, which is provided right here. So first, they have the jurisdiction and supervision over all corporations, partnerships, or associations who are grantees of primary franchises and or a license or permit issued by the government. Secondly, they can formulate policies and recommendations on issues concerning the securities market and advise the Congress and other government agencies on all aspects of the securities market and propose legislation and amendments thereto. Third, they can approve, reject, suspend, revoke, or require amendments to registration statement and registration and licensing applications. They can also regulate, investigate, or supervise the activities of persons to ensure their compliance. They can supervise, monitor, suspend, or take over the activities of exchanges, clearing agencies, and other SROs. Up next, they can also impose sanctions for the violation of laws and the rules, regulations, and orders issued pursuant thereto. They can prepare, approve, amend, or repeal rules, regulations, and orders, and issue opinions and provide guidance on and supervise compliance with such rules, regulation, and orders. They can enlist the aid and support and deputize any and all enforcement agencies of the government, civil or military, as well as any private institution, corporation, association, or person in the implementation of its powers and functions under this code. They can issue cease and desist orders to prevent fraud or injury in the investing public. They can punish for contempt of the Commission, both direct and indirect, in accordance with the pertinent provisions and penalties prescribed by the rules of court. They can compel the officers of registered corporation or association to call meetings of stockholders or members thereof under its supervision, in which they can issue subpoena ducis tecum, which is discussed earlier, and summon witnesses to appear in the proceedings of the Commission, and in appropriate cases, order the examination, search, and seizure for all the documents, papers, files, and records, tax returns, and books of account of an entity or person under investigation, as may be necessary for the proper disposition of the cases before it, subject to the provisions of the existing laws. They can suspend or revoke, after proper notice, the hearing of the franchise or certificate of registration of corporations, partnerships, associations, upon any of the grounds provided by the law. Indemnification shall be provided only in connection with such matters covered by the settlement as to which the Commission is advised by external counsel. The costs and expenses incurred in defending the aforementioned action, suits, or proceeding may be paid by the Commission in advance upon receipt of an undertaking. The commissioners, officers, and employees of the Commission who willfully violates this code or who are guilty of negligence, abuse, or acts of malfeasance, or fail to exercise extraordinary diligence in performance of their duties shall be held liable for any loss or injury suffered by the Commission or other institutions such as a result of such. Similar responsibility shall apply for, first, the disclosure of any information, discussion, or resolution of the Commission of a confidential nature or about a confidential operation of the Commission, unless the disclosure is in the connection with the performance of official function of the Commission or prior to the authorization of the Commissioners, or, secondly, the use of such information for personal gain or to detriment of the government, the Commission, or third parties. Wala, ang pangit. Dito na lang sa ano. Similar responsibility shall apply for, first, the disclosure of any information, discussion, or resolution of the Commission in a confidential nature or about the confidential operation of the Commission, unless a disclosure is in connection with the performance of official function with the Commission or prior to the authorization of the Commissioners, or, secondly, is the use of such information for personal gain or to detriment of the government, the Commission, or a third party. To achieve the goals of this code consistent with the civil service laws, the Commission is hereby authorized to provide for its reorganization, to streamline its structure and operations, upgrade its human resource component, and enable it for more effective and efficiently perform its functions and exercise its powers under this code. The compensation plan shall be comparable with the prevailing compensation plan of Bangko Sentral ng Pilipinas and other government financial institutions. It is subject to periodic review by the Commission no more than once every 2 years without prejudice to yearly merit review or increases based on the productivity and efficiency. The Commission shall therefore be exempt from laws, rules, regulation on compensation, position classification, and qualification standards. The Commission shall make its system conform as closely as possible with the principles under the Compensation and Position Classification Act of 1989.
For the RA 8799 Chapter 3 of Registration of Securities, in the Philippines, securities cannot be distributed or sold without a registration statement that has been properly submitted to the Commission and approved by it. So before the sale, each potential buyer will receive information about the securities in the format and with the securities in which order entered by the Commission with respect to such securities that shall be noted. At normal hours on business days, the public may see this register and any papers or information pertaining to the securities registered therein. The Commission may audit the financial statements, assets, and other information of a company filing for a securities registration whenever it believes it essential to ensure the full disclosure or protect interests of investors and the public. In the Section 9 of exempt securities, securities that are exempt from SEC or what we call Securities and Exchange Commission registration are those that can be offered for sale without regarding this registration. Federal or state government securities given to restricted group of investors, securities offered solely within specific geographic area, and securities applied exclusively to accredited investors are some of the most prevalent instances of exempt securities. Accredited investors are taught to possess the expertise to make well-informed investment decisions as they have significant amount of investing experience. In the section of 11, no person shall offer, sell, or enter into any commodity future contract except in accordance with the rules, regulations, and orders prescribed by the Commission in the public interest. So, the Commission has adopted rules and regulations regarding commodity futures contracts to protect investors and ensure the development of fair and transparent commodity markets.
Section 12 provides for the procedure for registration, in which first, all securities required are registered and sworn through filing in the office of SEC, which may require additional documents. Second, registration statement and written consent shall be signed by the issuer's executive officer. They also shall pay the fees no more than 1/10 of 1% of maximum aggregate price offered and declaration of registration statement. Lastly, state under oath that all registration requirements have been met and that all information are true and correct as represented by the issuer or the one making the statement. So, in terms of registration, the Commission can either accept or reject the registration. So in Section 13, rejection and revocation of the registration of securities, and here are the grounds for rejection. First is the issuer. If the issuer is found to be judicially declared insolvent, violated the provisions of the code, engaged in fraudulent transactions, made any false or misleading representation of material facts, failed to comply with the requirements of the Commission. Next is the registration statement is incomplete or inaccurate, or untrue statement has been given as a fact. Third is when the issuer or the controlling person of the issuer or similar function has been convicted or restrained by the Commission or judicial body or related bylaws. The Commission may compel the production of all books, papers of the issuer in case of the refusal. It shall be the ground for refusal or revocation of the registration. If a registration statement is incomplete or inaccurate in any material aspect, the Commission shall issue an order directing the amendment of the registration statement. Upon compliance with such order, the amendment registration statement shall become effective in accordance with the procedure of the Commission. An amendment filed prior to the effective date of the registration statement shall commence 45-day period within which the Commission shall act on registration statement. If it is filed after the effective date, the effectivity will be determined by the SEC. If the Commission finds the statement false or misleading, as mentioned earlier, the SEC can investigate and suspend the registration. Failure of the issuer, underwriter, or any person to cooperate or his obstruction or refusal to undergo an examination shall be a ground for the issuance or suspension order. Lastly, Section 15, suspension of registration. If at any time the information contained in the registration statement filed has become misleading, incorrect, inadequate, or incomplete in any material aspect, the Commission may require from the issuer such further information as it may judgment be necessary to enable the Commission to ascertain whether the registration of such security would be revoked on any ground specified in this code. Refusal to furnish information required by the Commission may be a ground for issuance of an order of suspension, and upon issuance, SEC shall conduct hearing. Until the issuance of a final order, the suspension of the right to sell shall be deemed confidential and shall not be published unless it shall appear that the order of the suspension has been violated after notice. However, if the Commission finds that the sale of the security neither be fraudulent nor result in fraud, it shall revoke the order of suspension and restore its status as registered security as of the date of such order of suspension.